Assalamualaikum warahmatullahi wabarakatuh. Hello everyone, let me introduce myself. My name is Luciana. Today, I will present our paper, and the title is Initiating the Pre-Bargaining, an effort to optimize the return of state financial losses on corruption. This paper is a collaboration of three researchers. They are Dr. Feby Mutiara Nelson, Emilia Febriani, and I, Luciana Primasari. We are from Faculty of Law, Universitas Indonesia. This is our paper outline. Our paper consists of four parts. First, introduction. Second, methods. Third, result and discussion. And fourth, conclusion. Okay, let's start to the first part, introduction. Background. Corruption is a big problem, not only for all Indonesian people, but also for all countries in the world. Corruption occurs in various sectors, both in the executive, legislative and judiciary powers and even the private sector. The rank and score of Indonesia's Corruption Perception Index or CPI based on data from Transparency International Indonesia for 2019 increased by 2 points to 40 compared to the previous year, ranking 85 out of 180 countries. In terms of the number of cases and the value of state losses due to corruption, according to the findings of the Indonesia Corruption Watch or ICW, the number of cases of corruption in 2019 was 271 cases with 580 suspects. The total state loss was 8.4 trillion with a total of 2,000 billion bribes and 3.7 billion illegal fees and 108 billion money laundering. Of the total state losses, if viewed from the value of the rescue of state finances that were returned by three institutions that deal with corruption, there are Corruption Eradication Commission, or as we know KPK, the Attorney General and the Police in 2018. The KPK recorded saving state funds of 500 billion. Meanwhile, the rescue of state funds by the National Police from corruption cases was much higher than KPK. It's 2.3 trillion in 2018. Then in the same year, the Attorney General saved 326 billion. Corruption causes many impacts such as environmental damage, for example, deforestation, and then poverty, loss of state finances or the country's economy, and hinders national development. Widespread and systemic corruption also causes violation of social and economic rights of the community. Therefore, eradicating corruption has become one of the main focuses of the Indonesian government. In particular, the eradication of corruption is regulated in the Law of the Republic Indonesia, number 31st of 1999 concerning eradication of corruption as amended by Law number 20 of 2001. The current orientation of law enforcement is still focused on punishing corruption with imprisonment, while the return of state financial losses due to corruption is not optimal in its implementation. If you pay attention, the law of eradicating criminal act of corruption in Indonesia still adheres to the retributive justice paradigm. Furthermore, Article 4 of the anti-corruption law also stipulates that the return of state financial losses or the state economy doesn't eliminate the conviction of the criminal offender as referred to in Article 2 and Article 3 of the anti-corruption law. From these provisions, it can be seen that the criminalization of the perpetrator contains the principle of retributive justice, which prioritizes the physical punishment of the perpetrator rather than the recovery of the crime. Based on these matters, it appears that the criminal justice system in Indonesia has not been able to optimize the return of state financial losses. From this fact, it then raises a study whether there are examples of paradigm shift in other countries that make returns to state financial losses optimally returned. The paradigm shift of sentencing in several countries in the world has now shifted, including the application of plea bargaining and deferred prosecution agreement or DPA by several countries. But in this article, the discussion will focus only on plea bargaining. Along with the development of human life and civilization, it turns out that the implementation of criminal sanction for the revocation of independence also contains more negative aspects than positive aspects. The negative aspects that arise from the imposition of the criminal deprivation of independence include the occurrence of the dehumanization, prisonization, and stigmatization. In addition, another negative aspect is the exhausts energy of law enforcers and state budgets to focus on physical punishment for criminals rather than on restoring the consequences of crimes committed. Whereas in many criminal cases, especially not in criminal corruption, the negative consequences or losses incurred by a crime are more important to be repaired than depriving the perpetrator of the crime of freedom. It takes a systematic and comprehensive effort to recover the consequences of corruption. For this reason, one of the efforts offered is to use a pre-bargaining mechanism. However, whether pre-bargaining can be applied in Indonesia, it is interesting to be studied further. Recent questions of this paper are: first, how the paradigm shift of sentencing in corruption, which focuses on recovering state financial losses, and second, what are the opportunities of Indonesia implementing plea bargaining in law enforcement against corruption to optimize the return of state financial losses due to corruption? Next part is methods. This research is a doctrinal research using secondary data such as legislation, books, journal articles, and electronic media. This research also using comparative legal methods. The United States and Pakistan were selected as comparison countries because the United States was the earliest country to implement plea bargaining, implemented many plea bargaining in its criminal justice system, and had many studies on plea bargaining, while Pakistan was chosen as a comparison because it is a country that has implemented plea bargaining in the criminal justice system as an effort to optimize the return of state financial losses. Okay, next part is result and discussion. Okay, let's go to the first result and discussion. The first is the paradigm shift of sentencing in corruption, which focuses on recovering state financial losses. What is plea bargaining? Based on Black Law Dictionary, plea bargaining is a process whereby the accused and the prosecutor in a criminal case work out a mutually satisfactory disposition of the case subject to the court approach. It usually involves the defendant pleading guilty to lesser offense or to only one or some of the counts of multi-counts indictment in return for a lighter sentence than that possible for the graver charge. Therefore, the main actors in the implementation of plea bargaining are the public prosecutors and the defendant or his legal advisor. Here, the role of the public prosecutor in proving his accusation is faced with the voluntary process of the defendant to admit his mistake. So there is an ease for the public prosecutor in processing a case. Here there is an actual concession, where the public prosecutor finds it easier in the process of proving the indictment, while the suspect gets relief in terms of his sentence. Plea bargaining is carried out with a plea guilty from the defendant in exchange for commuted indictment and or commuted criminal charge. With this process, judges no longer carry out examination at trial and can immediately impose penalties. Therefore, plea bargaining is considered cost-effective and reduces the burden on the prosecutor's office and the court. So, plea bargaining can be one of the solutions in optimizing the return of state financial losses. As material for a comparative study, let's look at the practice of implementing plea bargaining in the US and Pakistan. In US, regulation regarding the plea bargaining system in the US are regulated in the Federal Rules of Criminal Procedure, especially in Rule 11, Federal Rules of Criminal Procedure Rules 11 sub D, which prohibits the court from accepting a guilty plea without first hearing the defendant's testimony about whether the confession he made was voluntary and not due to pressure or coercion or other promises given by the public prosecutor outside of the plea agreement. The application of plea bargaining in the United States has made criminal justice in the United States effective and efficient so that criminal justice in US is able to prevent the incurring of high costs and long time in the criminal justice process. However, if we trace the development of plea bargaining, it is not only implemented by common law countries, but has spread to civil law countries. So, how about the application of plea bargaining in Pakistan? Plea bargaining in Pakistan as a formal legal profession was introduced in Pakistan in National Accountability Ordinance 1999 in NAO, an anti-corruption law. Its special feature is that the defendant submitted a petition, accepted the error, and offered to return the corruption results as determined by the investigator or prosecutor. Plea bargaining for corruption case in Pakistan is known in the National Accountability Ordinance 1999. In Pakistan itself, this plea bargaining only applies to corruption cases. The aim of implementing plea bargaining in Pakistan is to offer a defendant in a corruption case to return all assets obtained illegally in exchange for freedom, but with the reduction of political rights. The concrete form of sanction for defendant who plea bargaining is not allowed to participate in general election, hold public office, get a loan from a bank, and be dismissed from his position as a government official. Okay, from the explanation of the first subchapter, we can see that plea bargaining was successfully applied to optimize the recovery of state financial losses from corruption. So, can this be applied in Indonesia? Let's see to the next chapter. Second, the opportunity of Indonesia implementing plea bargaining in law enforcement against corruption to optimize the return of state financial losses due to corruption. Indonesia can actually apply plea bargaining. This can be seen in several provisions, namely Article 82 of the Criminal Code. Currently, there are still limited to violations that are only punishable by fines. We can also find in Article 152, letter E and F of the draft Criminal Code concerning the termination of the authority to prosecute if there is a settlement outside the process that reinforces the provisions of Article 82 of the Criminal Code, namely afternoon bidding process, but is broader in application, not only for violation and not just those they are threatened with fines only, but they are also threatened with imprisonment, which is similar to the transactional provision in the current Dutch Criminal Code. Another example is diversion, transfer of child cases out of the judicial process for children in conflict with the law or juvenile delinquent, as regulated in Law Number 12, year 2011, concerning the juvenile criminal justice system. Other examples of mechanisms that have been implemented in Indonesia are the Master Settlement and Acquisition Agreement or MSAA and the Master Refinancing and Note Issuance Agreement or MRNIA by the government is in the case of PLBE case. So, how to enforce plea bargaining in Indonesia? First, Naming of terms. The use of the term is not plea bargaining. Dr. Feby proposes the idea of the plea bargaining model or persetujuan mengaku bersalah or PMB in accordance with the context of the Indonesia criminal justice system and in accordance with the principle of simple, fast, and low-cost justice as follows. And then, regulated in statutory regulations. If plea bargaining is an opportunity to be implemented in Indonesia in the future, of course there must be arrangement in the form of statutory regulations, either regulated by a separate law or regulated in law, for example, included in the Criminal Procedure Code, so that law enforcers have legality in carrying out this and not solely at the discretion of the prosecutor or the Corruption Eradication Commission. And then there are special conditions or things that are negotiated in plea bargaining and criminal acts that can be negotiated in plea bargaining only that focus on recovering state financial losses, namely, for example, criminal acts in the economic sector, for example, corruption or money laundering. And third involves the criminal justice system. In addition to the public prosecutor or corruption eradication commission and the defendants or legal advisor, there are other parties involved in the plea bargaining process, namely the involvement of the Supreme Audit Agency or BPK as an auditor who will calculate the value of state financial losses, the value of compensation and fines to be paid by the accused. Another party involved in this process is an independent judge in the negotiation process. And the last is revising the criminal procedure code because criminal procedure code at this time is not compatible with plea bargaining. So changing the special rule in criminal procedure code. Okay, the last part is conclusion. So the conclusion of this paper are first, the paradigm shift of sentencing in corruption should shift from the retributive justice paradigm to the paradigm of punishment which focuses on recovering state financial losses, one of which is through the plea bargaining mechanism. And second, Indonesia has the opportunity to apply plea bargaining in law enforcement against corruption to optimize the return of state financial losses due to corruption by applying several criteria, including naming of terms, regulation, and special requirements, involves the criminal justice system and revising criminal procedure code. Okay, that's all presentation from us. I apologize if I make mistakes during this presentation. Thank you for your attention. Wassalamualaikum warahmatullahi wabarakatuh.